Presentation, before anybody tunes out, will be as follows. Michelle has told us how we can ingest marijuana. There's cookies, popcorn, brownies, what else, vaping. At the end of my presentation, I'm going to discuss what are the consequences of doing that in terms of gaining entry into the United States. So I'm a dual practitioner, part of the immigration group here at the firm. Dual in the sense that I practice both Canadian and U.S. immigration law, and admitted to practice both here in Canada and in the United States. So I've divided up my presentation into three parts. The first two deal with recent changes in Canadian immigration law, and then the third one is, as I just mentioned, the impact of Canada's legalization of marijuana, basically getting into the United States. So the first part on the expansion of biometrics collection. What are biometrics? First of all, the government of Canada is committed to the safety and security of all Canadians and the integrity of the immigration system, and they use biometrics. Biometrics are measurement of unique physical characteristics. So in the Canadian immigration context, it includes fingerprinting and photographs of the face. Canada has been collecting biometrics for many, many years, and recently dramatically expanded its biometrics program. Biometrics basically have three components. First of all, there's the collection of the biometric information. Then there is verification. Once the information is collected on individuals, every time that individual enters Canada, they can be fingerprinted and their information comes up on the screen. And the third component of the program is information sharing. There are 5 migration partners, including Canada, the US, Australia, the United Kingdom, and New Zealand. And all of these countries share biometric information. What's the big thing that occurred actually just a few months ago? On July 30th, Canada expanded its biometrics program to include citizens from all countries in Europe, Africa, and the Middle East. Previously, it was a very limited number of individuals who were subject to biometrics, and now there's a much broader application of the program, and by the end of this year, the program will include all nationals, not only from Europe, Africa, and the Middle East, but also Asia, Asia Pacific, and the Americas. On the slides, I've gone through a few points. I'm not going to go into any detail, how much it costs, how often biometrics are needed, once every 10 years, where to give them, where they're collected. The exemptions from the biometric program are Canadian citizens who are applying, are Canadian citizens or permanent residents of Canada who are applying for citizenship, and certain individuals coming to Canada as tourists who hold what's known as an ETA, an electronic travel authorization. Children under 14 are exempt, as well as adults over the age of 79. That's probably because it's hard to get the fingerprints at that age. And then the final point is heads of state and heads of government. Additional exempt individuals are cabinet ministers, accredited diplomats, refugee claimants, various other individuals. You can read them on the slides afterward. I just wanted to sensitize you to the existence of the program, the biometric program, and the significant expansion of the program, which started this past summer, and by the end of the year will pretty much include all of the globe. Another recent initiative of the Canadian government is known as the Global Skills Strategy. Global Skills Strategy is an innovative program by the Canadian government that recognizes innovative Canadian companies need access to highly skilled international talent in order to grow. And the program results in facilitative, quicker entry into Canada of highly skilled global talent. The next few slides are graphics which my team and I prepared for a presentation that I made to an IT group. And I'll go through it very quickly. There's a lot of information contained in these slides. I don't want to spend too much time on them because I want to get into the marijuana issue as soon as possible. This first slide describes the two governmental agencies that are involved in the Global Skills Strategy. On the left-hand side, you have Employment and Social Development Canada. The acronym is ESDC. They're involved in labor market testing, and they provide labor market figures, etc. On the right-hand side of your screen and on the slides, you see Immigration, Refugees, and Citizenship Canada, acronym IRCC. They basically regulate and govern all immigration and citizenship programs in Canada. Under this Global Skills Strategy, the GSS, there are 4 initiatives. In the middle column, you'll see the 4 initiatives. The first one is 10 business day processing of applications in 80% of the time. That's really fast for immigration. 10 days is extremely fast. Initiative number 2 is a dedicated service channel. They've set up contact information units for certain employers to have access to quick information from immigration. Initiative number 3, again in the middle column, is work permit exemptions. Sometimes when an individual is coming to Canada to work and normally would require a work permit to engage in that activity, if they're coming in under certain circumstances, if it's for a short period of time, then the government under this program has implemented work permit exemptions, so they don't have to go through the sometimes arduous process of applying for a work permit. The 4th initiative under the Global Skills Strategy is known as Global Talent Stream. And on the next page, next slide, I've described these 4 initiatives. On the left-hand side, you have the Global Talent Stream. Basically, it allows employers on an expedited basis to apply to ESDC and bring in employees quickly. That's category A. Category B under this category, under this stream, is the government has identified certain occupations which are in high demand. And if you're bringing in an employee in one of these occupations, again, you can get special processing. On the right-hand side of the slide, I describe the other elements of the Global Skills Strategy, all of which I previously mentioned, and this just provides more detail for all of them. Okay, in the few minutes that I have left, I would like to get into the impact of Canada's legalization of marijuana. My next slide is entitled, "Will Your Proposed Visit to the U.S. Go Up in Smoke?" The underlying legislation in the U.S. is the Immigration and Nationality Act. Under the Act, there are classes of inadmissibility, many classes of inadmissibility. The three which are relevant to the marijuana industry are listed here as criminal activity, health-related issues, and illicit trafficking. A finding of inadmissibility in any of these or many of these classes can result in a permanent bar from the United States. The bar can be overcome by an application. It's called a waiver of inadmissibility. It's very discretionary, takes a long time to be adjudicated, and one never knows whether or not it will be approved. Let's look at the three grounds very quickly. Criminal grounds, that means anyone convicted of a crime or a person who admits to having committed a crime, even though there's no conviction, or a violation of any law of a U.S. state or the United States government, in other words, a federal law, or a law of a foreign country relating to a controlled substance. So what's the situation currently in the United States with respect to marijuana? Currently, 29 states have legalized medical marijuana. 9 states have legalized recreational marijuana. However, and this is key, under U.S. federal law, marijuana is listed as a controlled substance, and possession or use is a crime under federal law. So even though it may be legal under state law, under federal law, it is not. What are some of the health-related grounds of inadmissibility? First one I've listed here is not relevant to the marijuana industry, but if one has a communicable disease of public health significance. If one has a physical or mental disorder, and associated with that physical or mental disorder is behavior that may pose a threat to property, safety, or welfare of the person who has the disorder or to other persons. And finally, a health-related ground of inadmissibility is someone who is determined to be a drug abuser or an addict. Now, a drug abuser or addict can be found inadmissible regardless of any harmful behavior. So one has to bear in mind the distinction between a physical or mental disorder which requires negative behavior, or a determination that a person is a drug abuser or an addict which does not require any negative behavior. The third ground of inadmissibility I mentioned is illicit trafficking. The risk of being found inadmissible is not restricted just to use or even possession of marijuana. Any person is inadmissible who the officer knows or has reason to believe has been an illicit trafficker of any controlled substance, or has been a knowing abider, abettor, assister, conspirator, colluder, etc. Now, the reach of this section for illicit trafficking is very broad. It includes family members. So, for example, a person who is found to be an illicit trafficker, his or her spouse, son, or daughter, who within the previous 5 years obtained any financial or other benefits from the illicit activity, may be found inadmissible to the United States. Let me give you some examples. I've listed a few here. One of my slides is real-life cases which just illustrate the examples. So I have 2 articles here, one from the Financial Post and one from the Star. The headline in this article from the Financial Post reads, I'm purely an investor. Vancouver businessman banned for life from the United States for marijuana investments. I won't go through all the details. Just very quickly, the government said he was aiding and abetting the U.S. marijuana industry because of his investments. Coming back to the aiding and abetting that I mentioned. Another story, very recent. Jay Evans, CEO of an agricultural equipment manufacturer, was crossing into the U.S. He had 2 employees with him. They began to design work on a machine that would streamline labor costs for cannabis producers. After 6 hours of being held in the secondary inspection, they were banned permanently from the United States for being drug traffickers under the drug trafficking ground that I mentioned before. What's the conclusion from all of this? Broadly worded immigration legislation and the lack of published guidance for officers will continue to result in roadblocks for Canadians and other non-U.S. citizens traveling to the U.S. The enactment of Canada's marijuana legislation coming up in a few weeks will likely lead to more uncertainty and inadmissibility findings. Travelers should stay informed about new guidance. This past Thursday night, I attended a meeting at the U.S. Consulate here in Toronto, together with a group of other U.S. immigration lawyers, and we asked them some very tough questions, and they all admitted that they really don't know. They themselves don't have guidance. They're winging it most of the time. They do expect that the government will be publishing FAQs, and I, of course, will be staying on top of it. We'll try to make it known through our website, and if any of you is interested in keeping up with this area, if you have investments in U.S. companies or you're involved in Canadian companies that have some association with the cannabis industry, very important for you to keep on top of these guidelines. Thank you very much.